Hello, everyone. Welcome, welcome, and welcome. Don't forget, if you are watching a replay, you can skip past this and get straight to the show. But until that time, we're going to give some people a chance to come on up in here. Hey, Carmela. Hey, Miss Leo. Hey, Miss Rod. Hey, Sunfruit. Hey, Zaire. Hey, my YouTube sister. Hey, Fundi. Hey, Miss Mary Mac. Did I miss anybody? This is not going to be a long video. It's going to be a short video because I'm just going to show you just the court case. Now, here we go. just put this up here. And put that there. And then let me put this here. And then we're going to start this case. Like I said, we're only going to do the case. Okay? And this is by, let me give them a little shout out. This is by Smash Rockwell. So smash it. All right, guys, I'm going to let it play. And I want to make sure you guys can hear it. I will not be stopping it. I'm just going to let it play and talk about it a little at the end, okay? Here we go.
Okay. All right, so we can do a 30-day reset status. All right, that'll be March 4th. Am I here? Yeah, 14th. March 14th. Okay. All right. Thank you, sir.
Judge.
Pleasure.
Nice to see you.
You too. So is John Herskowitz no longer in the state attorney's office then, I gather? Boy, I thought he was still there. Okay. I see Marlene Montaner for Asiel Duque.
Good morning, Your Honor. I understand the state is going to just request a reset for 10 more days.
Exactly. Reset 40th day, 2/21.
Can I get an ROR for my client?
I think the defendant was.
He's on house arrest. Good morning.
Isn't he out?
Good morning, Lindsay Davis for the state. He's on house arrest, Judge, so he's not entitled to an ROR.
All right, he is out.
I know he's out.
Did I lose Miss? Oh, there you are. Okay. Anything else?
Okay. No, I need to provide a new address for him from the location where he's at right now.
Okay.
I will do that with the house
Good
arrest
morning, Lindsay Davis for
with
the
the
state.
court.
He's on house arrest. Judge.
Okay, sounds good. Thank you. Yes, sir, Mr.
Judge,
Hernandez.
good morning. Judge, I have two matters. Page 1, JLO Wealth arraignment, Armando Hernandez
Yes,
on her behalf.
and we were waiting for the ASA.
Yes, Nicholas Chavez on behalf of the state. Your Honor, we're asking for a reset to the 40th day.
Right.
She is in custody.
And I'm asking for an ROR, Judge. We
All right,
spoke.
any good cause?
No good
All
cause,
right,
Your Honor.
ROR. And what's the 40th?
15.
February 15th. Arraignment. Anything else? You had
Judge,
another
I
case.
do have Mr. Paulino Velez, page 14. We're going to resolve that. We're going to wait till the end of calendar.
Okay.
It's an agreement.
Want to come back in
I'll
about an
be
hour?
All morning, Judge. I'll be here. So
Okay.
I'll come back in an hour.
Yeah, 10:15 should be good.
Judge, thank you.
My pleasure, sure. All right, we passed Mac. Divad Washington, page 7.
Your Honor, I reached out to Mr. Trons. He should be logging on shortly.
Okay, is that you, sir? All right, we're waiting for the attorney. We'll pass for now. And Alonzo Morales,
Good morning, Your Honor. Beatrice Laurenti on his behalf.
good morning.
And my client, just so you're aware, he's present in my office.
Okay. I have it on race status. This is Ms. Davis. Good morning.
Yes, good morning, Your Honor. Lindsay Davis on behalf of the state. That's correct. This is on for status. The defense has been taking some depots. I believe we have additional depots scheduled this
Wait, guys,
Friday.
shh, please, go ahead.
Yes, I believe we have additional depots scheduled for this Friday and next Monday.
All right, so where are we in the depot chain? I mean, how many have we got left?
Well, a lot, Judge. Let me give you sort of my take. And I just want for the record to be clear, because last time we were before the court, it seemed to me that the court thought that maybe we weren't doing what we were supposed to be doing. We took over the case last year, despite the case being in 2022. At the time that we took over the case, just so that Your Honor is aware, we filed our notice of appearance immediately at the beginning of the year, last year. On 6/28/22, the state sent us the rape stuff. On 7/1/22, they sent us a supplement report. On 9/21/22, they sent us the DNA file. On 11/3/22, they sent us the toxicology report. And on 12/2, they sent us amended discovery with some, I believe, additional witnesses. And on 12/9, since last is when I actually started to set the depots, because I didn't have complete, or I assumed I didn't have complete discovery, because that's what I didn't have. I set 9 depots at the beginning of the year. Despite there being 18 witnesses, some depots had been taken by prior counsel. Of the 9 depots from the state, only 4 of them showed up, and 1 showed up, but we were taking longer than not. I immediately reset those depots for the 10th and February. But in review, and at least only the 5 depots that I have taken, I've noticed that there's a J. Gonzalez that hasn't been listed. F. Moreno hasn't been listed. E. Lawrence hasn't been listed. S. Wong hasn't been listed. L. Wanton hasn't been listed. Paola Hernandez, Nicole Fabel, Stephanie Stella, Kay Bake has not been listed in the discussions with the individuals. We don't have the BWC camera of when the DNA swab was taken. We don't have the background on the witnesses referenced in the OIR report where Detective Walton did record checks of the victim, 2 witnesses, and the arrestee. We want those. We still have to take the depots of the DNA witnesses that were listed. Those haven't been set, particularly because we just got the DNA file. And one of the witnesses that's listed for February 13th called me to tell me that he was not available because he was going on vacation, despite us looking at his schedule before we set the depot. So I just want the court to be aware of all these things that once I've started taking depots and, seeing and interviewing the witnesses, that there's still a lot that it's not, I set depots when I think I have everything, and then I find out, oh, I don't have a lot and to be sort of fair to Miss Davis, she sat through some of the depots, so she's aware of some of them. Oh, and I'm also missing the notes that the officer Garcia, who now works for Miami-Dade, gave to the lead detective Napoleon the day of the alleged incident. He said they should be in the case file. I haven't gotten those
What kind
either.
of notes? What kind of notes are you talking about?
Whatever notes, but they reflect some witnesses that were interviewed there, but 2 of the ones that I just mentioned that were not listed. And I forgot to tell you the other part. The lead detective who was set for depot on the last setting that I mentioned, he canceled the day of the depot, saying he had a mandatory training. So
Okay.
I'm doing the best I can.
As it relates to these notes, you'll have to put that in a writing.
I will,
Notes
but
are
I
not-
wanted so that the court is aware, what's happening. And I will again put this on a motion to compel to let the court, know so we can get a motion. I'm doing an Oratanis motion now to say, hey, Judge, I've discovered all these things. I need to get them, and I'll put them in writing for Ms. Davis.
Right, Judge.
I wanted to do a more complete, I wanted to do a more complete motion because I've also already ordered the depot transcripts as well, but I haven't gotten the depot transcripts back, so that.
Business notice. So now that council has rescheduled them with the correct notice, we should not have an issue.
Actually, so that it's clear, only one of them wasn't given the 5-day notice. The others were.
All right, let me just make it clear for both sides. As of right now, the court believes that the state is on notice to preserve the notes. If in fact the notes are utilized and are compiled in some type of a report, the notes are no longer discoverable. But the state is on notice that these notes should be preserved if in fact they're not going to be used in a police report.
Yes, sir.
Let's, so what are we talking about as far as time? You want to do another 60
I think we should do a report in 60 days. And then once I get those transcripts and take the depots in the next, the 10th and the 13th, which is next week, I should have more. And then I'll put that motion in writing prior, hopefully, than the 60 days.
Yeah, I'd like to get those motions done by then, and then we will put this on our trial track. So let's do 60 days.
Thank you, Your Honor.
All right, April 19th for status. Anything else from either side?
Yeah, Judge, just let me make sure, because I think I have I want to make sure that I don't have anything. Yeah, I'm good that date. Thank you.
Okay, Ms. Davis?
No, Your Honor, thank you.
Okay, thank you.
Have a good day.
All
Bye-bye.
right, thank you. Okay, we do have, I did pass and I apologize. I saw, where are you? Piero Rodriguez, I apologize. I missed you on the Zoom. Where are you?
No problem, Your Honor.
Okay, behalf of Ariel Suarez.
Yeah, we're still dealing with this case, Your Honor. I've been trying to get in touch with Broward, and a couple of days ago they switched divisions on me with the ASA, so I had to start
Okay,
over.
does he need the assistance of the interpreter? Do we have the interpreter? We do not. Yeah, I would like him to at least know what's going on. Where's Alvin? Can we get an interpreter in here, Barbara, our Alvin?
Yes, Judge.
Okay. All right, siéntate por favor para interpreter, okay? All right, as soon as we get the interpreter, we'll call you back, State, if you can just remind me when they pop in.
Thank you, Your Honor.
So good morning.
Good morning, Judge. This is
Morning.
on page 27, I believe. Douglas Valverde, Robert Braun, Daphne, present, parents.
Okay. All right. Apparently, the state had asked to have this placed on calendar for the defendants, good morning, for the defendants to be colloquied with respect to an offer that has recently been conveyed by the state.
That's correct, Judge. The state did convey an offer to a global offer. So it's the same offer to both defendants to resolve the matter. And that offer would be that in exchange for the guilty plea, the state would reduce the charge from second-degree murder to a manslaughter with a firearm, which is a first-degree felony and does not carry any 10-20 life minimum mandatories. And then the sentence would be 10 years in state prison to be followed by 10 years of reporting probation. And that is again, would be a global resolution, which would require both defendants to close out at the same time.
And Judge, as to Mr. Valverde, he absolutely rejects that offer. And please feel free to colloquy him, but I've discussed that offer with him quite thoroughly. Okay, and he's not interested in that. We have made a counter to the state. I don't know I don't know for sure what the state wants to do about the hearing Friday, but
well, I gather if there is not a plea offer, we're going forward on the hearing Friday.
Well, we've made a counter offer.
What is the counter offer?
Pardon?
What is the counter offer?
3 years in state prison, followed by 3 years probation.
Your Honor, for Mr. Hernandez, Mr. Hernandez made a counter offer of 5 years, followed by 5 of probation.
And Judge, so the reason for that counter offer, quite frankly, is not the murder charge. It's because of the second charge. The carrying concealed firearm charge. And I believe that's a 3rd-degree felony punishable by up to 5 years. And I also believe he scores non-state. Should he be acquitted of the murder charge and found guilty only on the carrying concealed firearm charge. And all that's been discussed with Mr. Valverde, and the plea offer we've made is, at least as I understand it, is authorized by him.
Okay.
So, Your Honor, I did just receive the counter offers this morning. So that is new information. I do want to place on the record that as far as Mr. Valverde goes, for his benefit and for counsel's benefit, should he be convicted as charged of the 2nd-degree murder, he is facing 250 months in state prison at the bottom, up to life, with a 25-year to life minimum mandatory for 10-20 life. He is the gunman in this matter, so the 10-20 life minimum mandatory would apply should he be found guilty and the jury make the appropriate findings. And that is a minimum mandatory that is not waivable by the court. If he's found guilty and the jury does make the appropriate findings. Mr. Hernandez does not have the 10-20 life minimum mandatory, as he is a principal in the homicide and the did not possess or discharge the firearm. But he does also have 2 probation matters that are running along with this case, and the homicide charge is a violation, alleged violation of his probation. And so he's facing, he's got 2 third-degree felonies that he was on probation for at the time, and would be facing, if Your Honor found him in violation, and then could run concurrent or consecutive.
As an
those
HO, did you have him enhanced as an HO? I have.
Yes, I believe that's correct. If the
Got it.
clerk could,
I have it. So I just want, so he would be subject to 10 years on each count.
correct. What? The,
You've got him sentenced as an HO,
yes,
or you've been enhanced as an HO. So I just want to make sure he understands his exposure as an HO would be the 10 years on each count on the PVH. So, all right.
so that's correct. So Judge, because I did have the blessing of the next of kin to extend the offer that is on the table, I understand both defendants are rejecting it, but I do want to place that on the record, as well as obviously their counter offers. And then there are some legal matters we need to address regarding the stand your ground, but before we get there, want to finish the issue of the plea.
Okay. All right, I'll need to have both defendants sworn.
Raise your hand. Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Okay, I'll need to ask, I'll speak to both of you at the same time. Mr. Valverde, tell me your full name and your date of birth.
Douglas Valverde, September 14, 2000.
All right, thank you. And Mr. Hernandez. All right, thank you. Okay, Mr. Valverde, you are charged under case number F214616 as the A defendant with murder in the second degree with a firearm, which is a life felony, means that it is punishable by life imprisonment. And the second count is carrying a concealed firearm, a third degree felony that is punishable by up to 5 years state prison. The fact that there was a discharge of this firearm and there was a death, you are also subjected to a 25-year minimum mandatory sentence if in fact a jury is to find you guilty of this charge. That is not anything that the court can waive or the court can reduce or set aside. That is what you are facing if the jury finds you guilty. Do you understand that, sir?
Yes, sir.
Now, Mr. Hernandez, you are charged with violating your probation under, do you have the PBH? I have it, no? Yeah, I'm looking for it. I don't have it.
Did it print?
It should have printed. Maybe it didn't print.
It didn't print.
All right, well, what is the case number? Do you have that?
For the homicide?
For the probation case that he was on probation for?
For Mr. Hernandez.
Yeah, it didn't print.
I have the case number.
Okay.
The first one is F20-06243. And then the next one is 420-06.
Wait,
Oh,
420.
sorry. 420-8811.
Okay, F20.
8811.
8811. All right, and I don't have anything in front of me. So what was he facing then on the probation cases in a violation? Because I don't have the charges in front of me.
They're both third degree felonies.
One was a cocaine possession, I believe, and the other one was.
Egg and salt. Yes, both third degree felonies.
Okay. All right, so he was enhanced only on this case as a habitual offender then, correct?
As far as it's on the homicide case,
I have an enhancement filed for Mr. Hernandez.
case number.
On case number F214616B.
Correct, that's on the homicide.
Right,
So,
which is this
which
one.
is, and I'm sorry, because I was confused. there for a moment earlier. So yes, he's enhanced as a habitual offender as to the new law violation, which is the homicide, but not as to the
Right,
probation
that is
matters.
correct,
And so
okay.
he's facing a maximum of 5 years state prison on each, which could be run concurrent or consecutive.
Got it. All right, so sir, you are charged with violating your probation under case number F20-06243 and also F20-8811. In those cases, if you are found guilty by violating your probation, and again, the state only has to prove by a preponderance of the evidence, you would be subject to the maximum period of time in jail on those cases, which is 5 years, which could run consecutive, which would be a total of 10 years state prison. You are also charged under case number F214616 as the B defendant, wherein you are charged with murder in the second degree with a firearm. Again, also a life felony. So you would be looking at life plus the 10 years as a maximum exposure if you are found guilty by a jury of your peers. Do you understand that, Mr. Hernandez? All right. Now, as it relates to Mr. Valverde, the state has made an offer as of right now, and apparently it is a global offer. And I'm telling this to both of you now, that this global offer is offered for today. I understand through your lawyer that you are rejecting that offer, but I just want to make sure that you understand what the offer is. The offer is to plead guilty to a reduced charge of manslaughter with a firearm, which does not involve that 25-year minimum mandatory. It is a first-degree felony, which means that it would be punishable by up to 30 years state prison, but they're offering you a 10-year state prison plea, followed by, is it followed by 10 years reporting probation, and is the state silent on early termination?
Yes.
And the probation would be eligible for early termination at the 5-year point. This would prevent you from having to do this minimum mandatory sentence. Have you had the opportunity to discuss this offer with your lawyer?
Yes.
All right. Do you have any questions of your lawyer before you answer me whether or not you wish to accept or reject this offer?
No, sir.
All right. So what is it that you wish to do? Do you wish to accept the state's offer or reject it, knowing that if you reject it, the offer is going to be off the table at this point?
No, I reject.
Okay. All right. Now I'm going to ask Mr. Hernandez. Have you had the opportunity to discuss the offer, which is an adjudication of 10 years state prison, followed by 10 years of probation, again, to the reduced charge of manslaughter with a firearm, and you would also be admitting to the violation of probation, and your probation would be revoked with 5 years state prison consecutive to each other, but concurrent with the manslaughter sentence, which basically is a 10-year state prison sentence, followed by the 10 years reporting probation. With that probation, they're being silent. So you could terminate the probation also after 5 years. Did you have the opportunity to discuss that offer with your lawyer? All right. And what is it that you wish to do? Okay. Do you need to ask him any questions before making a final decision? Okay. So both sides having rejected the offer, that basically puts us in the posture that we were as of yesterday, that we are set for trial. I know that as it relates to Mr. Valverde, we do have a stand your ground hearing set for Friday.
As well as Mr.
Oh, Mr. Hernandez adopted the,
Easter.
okay, that's right. Okay, so as it relates to that, both the defendants will have the stand your ground hearings on Friday. And now I do know that there was a counteroffer made to the state. You know, discussions can always take place between counsel, and I'll allow that to happen. Anything else on this matter?
Yes, Judge. So the additional issue, which I didn't have a chance to completely review everything before requesting the calendar date for today, but I have received a fair amount of reciprocal discovery from the defense, and I understand it was provided on behalf of Mr. Hernandez. And then as of yesterday, I believe Mr. Farrar filed a notice of his intention to adopt all of those same
Is it
exhibits.
the DB injunctions?
Yes.
Yes,
Okay.
as
Yes. Yes, all of it, Judge. And we also filed a request for the court to take judicial notice of the filings and
Right.
that I don't recall the case number.
Okay.
Correct.
I remember that.
It's what I call the injunction case.
Yeah, and with respect to that, I mean, state now is on notice. It's a part of a court file. Chances are 99.9% that I'm going to be taking judicial notice of it.
Yes. So the issue is, so there's the injunction matter, which, to remind the court, the injunction is between the brother of Mr. Hernandez and the victim, not between either of these parties and the
Just
victim.
because I take judicial notice does not necessarily mean that it's admissible. So I want you both to understand that ruling. Okay.
Yes. So, but I bring this to the attention of the court because, so in addition to the injunction matter, there were also some text messages, social media posts, and audio recordings. Because the injunction itself, the state was aware of. We had been provided it earlier in the case, and as well as discovered it through our own investigation. But the messages and some of the audio recordings, although there had been some discussions with defense that there might be material out there, it had not been provided to the state. I do intend on filing some legal, a little bit of a legal briefing with regard to the admissibility and under what circumstances for each of these particular pieces of evidence. And it was my hope and intention, because we have this hearing set for Friday, to get everything to the court in order to not cause any delay. But it turned out to be a little bit more materials than anticipated. And so that, combined with the counteroffers that are on the table, Ms. Hogue is out of the jurisdiction until mid next week. And so even if I wanted to bring it to her attention, I will not be able to do so before Friday.
The counteroffer, you mean?
Correct. And so I'm not making any representations as to whether or not that, the state is, what our response is going to be to that counteroffer, because I need to have further discussions with the family, which I can absolutely do before Friday, but I cannot bring it to Ms. Hogue. The position of the parties know, which is why I had the case placed today for a colloquy, is that once the hearing goes forward, we are not negotiating further regarding the case. So I guess that's a lot of things to say.
Objection if you would continue with the Fridays, we provided that over fairly recently, and I think it's in the best interest of this case, given that we're getting much closer to resolve this matter. So on behalf of Ms. Hernandez, if this takes like a little bit more time, a 1-2-week reset,
Mr. Barrar?
Fine, Judge.
All right, so without objection, we will go ahead and continue this Friday hearing. Couple of issues raised. First of all, I do have a question. These text messages are from whom and to whom are these text messages sent?
Some are to my client directly, and others
To your client from who?
from the victim,
Okay,
threatening to rob him, beat him up and this stuff. And then the others are to my client's brother, the same nature, threatening him, harassing him, and also my client lived with his brother, and his brother would show him, hey, can you believe this guy's saying? Go, this guy's saying.
okay.
And then the injunction is incredibly valuable because the injunction is because the victim did the exact same thing. My client's brother slapped him outside of a tobacco store, had a pit bull, and threatened to gun him down.
Right.
The facts
Okay.
are-
Now, that's now that I've gotten that answered, a couple of issues you reminded me. So I was provided these DVDs. Who gave me these? The state? Is this your writing or?
I believe those are from the Arthur hearing we had with Mr. Valverde, Judge. I did not provide any additional materials.
Well, I hope it's not from the court file, because I could tell you they are all blank. I've gone through with our technicians, and these are all blank. So do you have some type of CDs or some type of vehicle of recordings in the court file? And you can look at them and you can see that there's been nothing cut on that. I mean, they're completely blank.
So it's possible that that's the only materials that were provided were prior to Mr. Valverde's Arthur hearing, and that was
What I was thinking, maybe.
provided because we did the hearing over Zoom because that was during the COVID closure.
Right.
Height of COVID.
So you don't have actual recordings in the file? Because we are gonna need that, and I need to get a stipulation from both
Yes,
sides.
I believe we have it as in the vault.
You do?
Because,
Okay.
Indira had to check.
Whose handwriting is this? Maybe you can say, but they're all,
Yes, that's mine.
I was gonna say, without looking, I'm sure it's not mine.
okay.
These were provided by the state, and I apologize that there is an issue with them.
Yeah. So if you want to just take them back because they're empty.
They wouldn't even give it for a mixtape.
Unless, from what I've understood from our technician, that is so antiquated now that he just said that people don't even use, my computer doesn't even have a CD
Wow.
space anymore.
And I had to buy one just for this case.
Oh, okay.
Because my desktop doesn't have a thing on the side. Put it in.
So if you want to get me a thumb drive perhaps, or maybe just send it electronically and I can store it in a file electronically is fine. But yeah, just because I did want to review the evidence before we had the hearing, but now I have a little bit more time, which is good. So with that said, we will continue the Arthur hearing for, how much time do you
You
need?
need to stand your ground here.
I mean, the stand your ground hearing. How much time?
Well, Judge, when I imagine we may be somewhat constricted by your honor's calendar, I don't need a too terribly long of a reset, but I know that the court has a lot of other matters scheduled, so.
It wouldn't matter. Let's just, if you give me a day, we'll start from there. You want to? Barbara, how does March 3rd look?
Let me check.
What day is that? Would the second work? I know it's better for the detective to do this.
March 3rd looks good so far.
Okay, March 3rd.
Let me check something else.
So you said March 3rd is not good. You're in Broward?
Second, the state required of.
No,
Oh.
the March 2nd is the plea blitz, so that doesn't work anymore.
Right.
So I just know the detective is off on Friday, so I was,
Oh.
but he will make arrangements to be here as long as he has notice. That's what he was going to do for Friday.
Okay. All right, so March 3rd, both sides agree?
At 11.
Yeah, we could probably get started at 11. Shouldn't be too bad.
And that's the stand your ground here.
Correct.
That's fine. With the state schedule, I will double check today with the detective just to make sure, because like I said, he is off on Friday, so I want to make sure he didn't have a pre-existing conflict, but as long as he didn't, well, let's take that date for now, and I'll advise everyone if there's an issue.
And that's at 11 o'clock.
11 a.m. Yeah.
Okay. Judge, my excuse, I've got to run to a couple courtrooms.
Unless you want to sit for the rest.
Talking and not feeling, well,
Okay.
we already called his case. Just so that your honor knows, he's on case 5, Jimmy Lee Burnett. And the case is recessed at the 30th day. It's recessed to February 17th, and I just
Right.
wanted your honor to know who's present for it.
Okay, all right, thank you for being here, sir. Okay. Give me a second, because let me just announce something. There is a case that is on the calendar for page 11. Michael Nowak. And I know that there apparently are people who are shown up for him. This matter was continued. It was an agreed motion to continue. And so just to let everybody know, it's being continued and set for trial on May 1st of 2023. All right, so everybody who was here on the Michael Nowak case, it has been continued, agreed by both sides for May 1st, 2023 for trial. If you need that. So let's go back. Yeah. Oh, yes, we did need the interpreter. Thank you. Good morning, sir. I'm good, thank you. If we can have you sworn.
Sir. Do you swear affirm to interpret from English to Spanish, Spanish to English to the court without an answer given to the best of your ability?
Yes, sir, Mr. Clerk, I do.
Thank you. He's in the box. All right, what is the defendant's name? Flores. Oh,
It's recessed at the 30th day. It's recessed to February 17th, and I just
Right.
wanted your honor to know who's present for it.
Okay, all right, thank you for being here, sir. Okay. Give me a second because let me just announce something. There is a case that is on the calendar, page 11. Michael Nowak. And I know that there apparently are people who are shown up for him. This matter was continued. It was an agreed motion to continue. And so just to let everybody know, it's being continued and set for trial on May 1st of 2023.
And there you have it. And there you have it. Hey, B. Barkener. Hey, Demetrius. What's up, sis? Ewin. What's up, my love, my yacht, Ms. Ride, B. Barkener, my Bush babies, Sunfruit, Gary. And if I missed anybody, I'm sorry. Zaire, hey, what's up, Geechee? I wanted you guys to hear like some other cases too, because that's what I always do. Could we be getting all into it? What happened is they didn't even discuss it. Both cases decided to just go to trial. They decided to go to trial, which the trial would start. I believe they said May 1st. The trial would start I think he said May 1st. It will continue, but I could go back a little bit because we're going to be on that case. We're going to be on Nature Boy case. We're going to be on everybody case. And not to mind, your Nature Boy case wasn't even, ain't even got no date yet.
And so just to let everybody know, it's being continued. The calendar, page 11. Michael Nowak.
Which is Polight.
And I know that there apparently are people who are shown up for him. This matter was continued. It was an agreed motion to continue. And so just to let everybody know, it's being continued and set for trial on May 1st of 2023.
I don't know.
All right, so everybody who was here on the Michael Nowak case, it has been continued, agreed by both sides for May 1st, 2023 for trial. So
there we have it. So y'all can't say I don't keep y'all up with the news. I keep y'all up with these things. Yes, attorney was present. I don't know if he's pleading not guilty. I think he is pleading not guilty. That's why he's going to trial. Yes, keep these YouTube streets up to date on these conscious cases. That's right, Demetrius. Then we got young Pharaoh. He's sleeping on a he's sleeping on an air bed with no air in it. Oh God. I thought they had body fluid evidence. See, the trick to that is it's on a shirt. We don't know how it got on a shirt. She says it got on the shirt one way. We never heard his side. See, he know how to keep his mouth shut. Oh, he pushed the Cinco de Mayo? Yes, he did. See, I keep you guys, I try to keep you guys know what's going on all over. But I just wanted to show you guys this trial. And I told you I wasn't going to keep y'all up all night. But tomorrow we will be back at it. He can't say he didn't get a lot of time free. Wait, yeah. What he should have did, What Nature Boy should have did was like, yo, Polite, how you do that? How did you do that? But he said he was God. He said he was God, and he mocked them. You can't mock the police and mock God. How you gonna go around mocking everything? He done mocked everything, everybody. I guess he levitate. Let me stop, guys. Nature Boy is levitating right now because he done past 60. He probably say he was drunk and she was the aggressor. You know, man, listen. That girl ain't had no business there, period. But who knows? Who knows? Because they didn't keep him, which means they didn't see him as a flight risk. They didn't see him as having influence, like Dum, like Dummy, still making phone calls, still got everybody making videos, got everybody talking about, oh, she's a this, she's a hoe, she's a slut, she's a freak. Got a different guy every day of the week. He didn't do all that like Nature Nut did. Good night, sis. Yes. We're gonna keep up on all of them, actually. Y'all heard how Sonetta done cursed the girlfriend out. He done cursed the girlfriend out. But we're gonna keep up. But I just wanted you guys to see. I don't know how he did it. I don't know how he do it, but he done did it. He got more days free out in the public. So he got February, March, April, May. He got 3 more months. She needs 16 more people, Ms. Rodney. She's just so close. She's just so close. So close. Hopefully we can get her there. We can get her there. Support her. Ms. Rod is 16 away from her goal. If you would like to subscribe to her channel, that would be beautiful. That'd be beautiful. Pushing 3 more months. Yes, and yes. And you know, I like to thank all of you guys for being here, even my Bush babies. I thank you. But give me 1 second. Give me a second. Yeah, girl, they was going at it. I'll probably show that. Tomorrow. I gotta keep y'all updated on this stupidness. Gotta keep y'all updated. But anyway, I will see you guys later. And y'all know what I gotta leave you guys on, right? And I'm gonna leave you guys with this. Peace, guys. I am out.